Hi, Adam Cooper here from Cooper Family Law. We all have a reasonably good understanding of the purpose of a will. The law gives adults the opportunity to make a written statement setting out where your assets go and who they go to. Most people also understand that if you do not have a will, the government decides via the laws of intestacy in each state. Now, whether it is to ensure the ongoing support of family or friends, or to donate to a charity or other important organisation, or to ensure family treasures stay in the family, a will is your single source of authority to determine the transition of your estate. It's not surprising, therefore, that when people think about making a will, one of the key questions will be, who are the beneficiaries? That is, who will benefit under the will? However, even before we get to that question, the key initial question is, what is my estate that is transferred under the will? You may be surprised that not all of the things you own or think you own go into your estate for the purposes of your will. In this video, I will set out as concisely as possible the nature of an estate for the purposes of the law of Queensland, which is reasonably similar to other Australian states, as at the date of the video. This information does not replace legal advice as you would receive about your particular situation, but it is here to get you to start to think about the right questions so that you'll get what you intend. Okay, so what's an estate? Essentially, it's all your property, which are your assets and your liabilities, your things, your debts. A chair, a car, house, money in a bank account, shares, companies, as well as personal loans, home loans, credit cards, etc. Because that covers a whole range of things, I'm going to now talk about what is not in your estate for the purpose of your will. The first is probably the house you live in. That might seem odd, but it's true. If you own a house and you own it jointly with another person, such as your partner or spouse, so that you are joint tenants, then when you die, the house simply becomes theirs, and vice versa. If they die, it simply becomes yours. Your 50% of the house does not go into your estate, neither does theirs. Now, if you own a house alone or with someone else as tenants in common, then that is different. Owning property in your own name is yours to bequeath in your will, or any interest in a house other than property as a tenant in common. If you don't know or don't remember how you hold your house, it is not a bad idea to check. You can search titles online for a small fee, or a lawyer assisting you with your will can do the search. The next thing that does not go into your estate is your superannuation. Why? Because the funds in your superannuation policy are not yours, certainly not until the property vests. They belong to the trustee of your superannuation fund. Even if you're the trustee of your own superannuation fund, you still do not own those funds as a beneficiary, so they do not form part of your estate. This also applies to life insurance policies or any other property that is held on trust for you. Now, most of you would be aware that you can give beneficiary nominations to your superannuation fund. They can even be binding on the trustee, so the trustee must comply with the nomination. However, if you do that, you need to do so regularly. The rule of thumb is that you need to update your nominations every 3 years. Your fund may be a shorter period of time, so it's good to go online and check. Most good funds have nomination information on their websites. Now, you might be wondering, if the house and super does not go into the will, what's the point of having one? Well, the short answer may be that there is no point. But of course, you will have other assets, and it may be that you wish to set up a specific trust for your children. So it's still a good idea to at least discuss with a lawyer what the best plan of attack will be for your will. Finally, I'm just going to quickly go through a few things that cannot go into a will. For instance, Facebook, YouTube, and other online accounts, even if they are income producing, cannot go into a will. Your executor can certainly make arrangements for those accounts to be deleted or memorialised, as they call it, but they cannot be bequeathed. Bitcoin, another cryptocurrency, can be bequeathed, but it is a very complicated process and specific advices are needed. Reproductive body tissue never used to be able to be bequeathed, now it can. And finally, you can't bequeath your children, they are not your property. You can certainly make a statement in your will which states who you might prefer to look after your children, but this is not binding on anyone, least of all the family court, who have the final say on disputed care arrangements for every child in Australia. So there you go. Hopefully you've got some information that may assist you when you think about preparing your will. Best wishes and stay well.